Okay, welcome everyone to this Do It in Durham event. I just want to welcome Pavel as well for taking the time to be here. As many of you know, this is our 10th year doing Do It in Durham, which is an initiative that we've created. BACD is the lead organizer who have collaborated with different community partners, sponsors, the municipalities in Durham region, and we're really excited to celebrate this during Global Entrepreneurship Week, which takes place in over 200 countries. And it's 1 week in November, and we're really proud of it. And we hope that business owners can take advantage of this week and soak in all the information and knowledge that is provided. Most of the events are free, and we still have lots of events happening until the end of Friday. So please check those out and take advantage. If you are posting about the events or what you're learning, please use the hashtag DoItInDurham 2022 and hashtag GEW Canada 2022. And you can check out more of our events at doitindurham.biz. And with that, I will hand it over to you, Pavel. Sorry, I'm just going to actually take one more moment to thank our sponsors, very, very important, and our collaboration partners. We have the cities, we have radio stations, we have RIC centers, research and innovation centers that have all come together to help put this week on. So thank you so much to our sponsors and our partners. And now I will stop sharing my screen and hand it over to Pavel.
Okay, then hi everyone again. Couple of words about myself. I'm a business lawyer, meaning I practice corporate commercial work. I practice law in this country now have been practicing for the second decade. I'm part of a regional full service firm called Locker and Hine. We are a team of 12 lawyers practicing in mostly all areas of law, excluding some fancy niche practices. And as I said, my practice is business law. So I provide legal support to businesses from the inception, whichever form it takes, a corporation or any other form, and I provide support through the whole life cycle of a business. So that's all commercial transactions, corporate transactions, organizational things, and so on. I also do real estate deals as a lawyer. So I close purchase, sale, financing, refinancing, of residential and commercial properties. And the third thing I'm doing is I'm practicing wills and estates law. So if you ever have any questions or need to pick a lawyer's brain in all these three areas, so you're welcome. My brain is to your disposal. And also in addition to my practice, I'm also the adjunct professor at Osgood Hall Law School, and I've been teaching now since it's 8 years of teaching. I teach legal drafting, and also I've taught a intensive negotiation course. So that's what I do when I am bored with my legal practice. Now, today, what we will be talking about is we will be talking about electronic commerce agreements. So that's we all need to have when we're doing business through our website, for example. So we're doing online sales, we're maintaining our website, we're posting on some useful content for people, something for sort of self-education, some is to explain our business. We also sell our services online. We also collect personal information from our customers for different reasons. We also want to send some marketing communications to our clients, hoping that it would increase our sales. And we need to have a piece of paper for all of these aspects. So let me share my screen.
Yes, and while you're sharing your screen, I'm just going to go through some of the businesses we have in here. So
wonderful.
We have accountant and taxes, a creator of Bath and Bower, which is a luxury candle studio in Whitby, e-commerce. Medic Stocks, which sells scrubs, retail, launching an e-commerce website next month. We have someone who's in the field of meditation and mindfulness facilitation for chronic pain, trauma, and stress. Awesome. Retail gifting. We have fitness instructor, personal trainer, online and in-person, specializing in 50+ adults. So far, those are the types of businesses we have in the room.
Okay, wonderful, wonderful. So we'll be talking today about electronic agreements. And as I said, if you have questions, I will be more than happy to answer questions. And that's, questions today. So during our presentation, don't hesitate, just raise your hand through this Zoom options, or in any event, if you have any questions popping up your head afterwards, then just send me email or call, so we will talk. Okay, electronic agreements. Next slide. First of all, lawyers love disclaimers. Here's my disclaimer. I'm not providing legal advice today, so that's for educational purposes only, because every situation might be different. Now, what we're talking today, we are talking about different types of agreements that we're using in our electronic commerce. Say, as I mentioned, we have a website, and we want our customers or even visitors to our website to commit to certain, say, code of conduct or rules of conduct on our website. And that's we will be talking about this use of website terms. Second, we are selling our goods, or we're selling our services through our website, which means we don't transact face to face, but we do transact online, virtually, and still we want to have our agreements with the clear terms, and we want our agreements enforceable and valid. We will be talking about them, about validity of agreements, and about by the way, consumer protection. That will be especially important things for those of you who is selling services or goods to consumers, and we know the difference. We know what consumers mean. That's it's a people, individuals or households buying our services and goods for their own use, not for resale or not for use in their businesses. Say, when I'm buying a toilet paper at Metro, I'm a consumer, and when I'm buying a toilet paper for resale, I'm not a consumer. So that's and consumer protection. The government is placing a much higher expectations of vendors when dealing with consumers, and I will discuss that with you. Now, we collect privacy, we collect personal information from people, and also there are certain expectations and legislative guidelines what and how we need to do. And also, as I mentioned before, we are sending our say, marketing communications to our clients or potential clients, and we don't want to go a full with this anti-spam compliance, because that can be uh, draconianly expensive. No, and the cookie policy, that's it's a part, I would say, it's a part of privacy regulatory regime. So first, why we need, as I mentioned before, why we need a proper enforceable agreements. First, we want to make sure that when we transact with people, our rights and their obligations are enforceable. And also, we want protection from civil liability, say for misrepresentation or for some sorts of unfair dealings. Now, number three is a big item. We want to make sure that we stay within the parameters of federal and provincial regulatory regime, and that's specifically for privacy protection, for cookies, and for this anti-spam legislation. So, like, obviously, when we are talking about our marketing information and our communications, it's a fine balance. We were balancing marketing and liability. So on the one hand, we want to provide information, or we want to sell ourselves, we want to sell our services, we want to make our services and our website and the information that we are providing, we want to make all this attractive to potential customers, correct? But also we we need to make sure that we're providing correct information, accurate information, and that we're not exposing ourselves to liability for, say, just simple example, some sort of misrepresentation, for example. So, but also at the same time, we don't want to scare away potential customers from us, right? So that's a it's a fine balance. Number one, let's talk about just I'm not going to overload you with this technical information or this legalese about um, these electronic commerce requirements. I will just very quickly explain you the most important things you need to know for practical purposes of your online business. First of all, a electronic agreement, any electronic document can be just as good as a hard copy document. So that's number one to remember. And the electronic signature can be absolutely just as good as a ink signature on a hard copy, and that's with a certain exemptions. That does not apply to. It's a narrow spectrum of documents. It's a wills, it's a powers of attorney, it's a trusts, and certain negotiable instruments. And again, there is a prescribed list in the regulations, but again, it's a very narrow list. Other than that, you can do your business online, you can do online agreements, you can sign documents agreements, you can sell, buy, lease, transact and contract with people online. So that's completely fine. Very briefly, this electronic commerce act that regulates these electronic agreements, they operate with a certain terminology. Again, very quickly, I don't want to overload you. Electronic, so when we're talking electronic means that's through virtual way of communication, not face to face. And electronic agent means any type of application that remits or sends, basically transports our messages from one party to another. It can be Facebook, for example, or it can be our electronic instant messages, or it can be our email. So that's all electronic agents. Electronic signature, we now know that COVID has taught us to sign documents. We work with DocuSign, we work with signable PDF, so it's completely fine. Consumer, we know that's it's a consumer agent, so we know that that's people at that situation when someone is buying something for their personal use. And obviously we know internet, it's a world web, so that's how and where we do our business online now.
Pavel, there is a
Yes,
question, sorry,
yes, yes,
um,
yes,
from Roxanne. So
yes.
do e-contracts protect civil liability in a sole proprietorship business?
Maybe Roxanne, maybe you can explain a little bit, what do you mean e-contracts protect civil liability?
I'm just asking because for sole proprietorships, the liability is with the owner and not the business. So I was wondering, like, does the contract add an extra
Oh,
layer
I see what you mean.
for sole
You know
proprietorship?
what? It's a
Yeah.
little bit different. So the type of or the form of agreement has nothing to do with uh, insulating yourself from the business liabilities. And sole proprietorship is it's an individual. So the best way to separate yourself from your business liabilities, to incorporate your business. So
Okay.
that's what gives the owner of the business protection, even if it's a one-person business. Say
Okay.
where you are in all three hats of a shareholder of the business, sole shareholder, and a sole director, officer, and an employee of your corporation doing business just you. Still, you will be protected. And in a sole proprietorship situation, no, that's it's your individual liabilities.
Okay. Thank you.
Okay, so if you need to speak about incorporating, let me know. I do it.
Okay.
Um, Now, again, very quickly, that's a validity of electronic agreements. That's all governed by this Electronic Commerce Act. Obviously, um, that's a electronic document can be as good as a written one, provided certain conditions are met. It means that an electronic document needs to be as accessible and usable for subsequent reference. And why I quoted unquoted it, that's actually a verbatim taken from the act. So the idea is that uh, when we operate in electronic agreements or any types of documents, we need to make sure that our counterparts, our customers can actually access the document or, for example, download, print, do something to retain the documents on their side. So that's then they talk about provision of written information. So how we can do it in electronic form. That's the same thing. We need to make sure that it's accessible, usable, and capable of being retained. So that's either sent as an attachment in email, or it's provided as a hyperlink so that someone can click on that hyperlink and download on their side on the computer, and obviously print, use, read, and do whatever they want with a paper copy, for example. Now, there is a specific specified non-electronic form. So, for example, if there is a document, say some government form that is organized in a particular way, it means that an electronic document needs to be organized and being able of retention in the same form. It's easy. It's not rocket science. Next. Same, a regional document. Say, oh, I need an original. Please send me the original. An electronic document can be as good as say a regional document. Again, that's you just need to make sure that how they say it in the act, that's you need to provide a reliable assurance as to the integrity of the information, accessible, usable, and again capable of being retained. So that means that a PDF or DocuSign signed document is as good a regional document as ink on paper. Okay, capable of being retained. We understand it's just printable, storable. You can download it on your computer, then store it or print, do whatever you want with the document. And provided, obviously, document provided. Here's a tricky thing. It's not sufficient to make a document available for access on a website. No, no, no. We actually need to provide it, say by email, by fax, by say sending as an attachment on WhatsApp, Facebook Messenger, or Viber, or any other type of this electronic agent. Okay, so just we need to remember this. And same electronic signature, that's as good as a ink signature, as long as it's reliable in terms of personal identification and association with the document. It's easy. Now, sometimes in very rare situations a seal is required. Okay, there are solutions for that in electronic agreements too. Then retention of electronic agreements, they are big on it. Yes, electronic copy, just as long as you make it accessible, usable, and provide the information on the region, destination, and date of the document, we are fine. Now, talking about how the contract is formed, we know it's a basic thing that the agreement consists of two parts. It's an offer and acceptance. I offer you something, you accept my offer, we have a deal. And how about doing this electronic form? It can be in all sorts of forms. It can be an email with the proposed terms that is accepted on the other side, or it can be by, say, electronic agreement on someone's website, saying you're clicking I agree or yes, please proceed. And in terms of, okay, where we are here, say typically with the electronic agreements, say when you're doing all this through your website, you will want to make sure that you can somehow document, record the act of positive acceptance. Say we all understand, say click I agree, click buy something, buy it now, or some other option, to make sure that yes, the other side made some sort of like active action to confirm the acceptance. Okay, And sometimes we're all humans, we're not perfect. Sometimes there will be some errors in our electronic communications. How to deal with them to make sure that our electronic agreement is still enforceable. First of all, that's it needs to be like first two things to remember: one, notice; second, correction. Say that's why, by the way, say when we're doing our banking online, then that's why we ask like 57,000 times, yes, please confirm the information is correct, please confirm to proceed, please click, please now transact, complete your transaction, and so on, so on. And even after that, we will be asked, okay, please confirm that that's exactly what you wanted to do. Okay, now consumer protection, it's a thin ice. First of all, that's a Consumer Protection Act. It applies to the threshold is very low, so it's anything over $50, and $50 is like these days, $50 is nothing, which means whether these are consumer transactions, anything over $50 is subject to this legislative consumer protection. And there is even one particular chapter in the act dealing with internet contracts. And we need to be especially careful when dealing with consumers. First of all, it's again, it's legislative language. We need to provide clear, comprehensible, and prominent information. So that's informational disclosure: clear, prominent, comprehensible, comprehensive, and comprehensible. That's specifically about vendors' full information. Then a fair, accurate description of the goods. And my personal problem is with the word fair. What's a fair? Accurate description, I understand. If I'm selling an apple, it's an apple. If it's this honey crisp, it's a honey crisp apple. But what's a fair description? And so fair, the word fair is it's a tricky word. So the moral here is the more information you provide, the better. Okay. Now, obviously, the price information, because people hate, like I say, hidden fees, hidden like editions, charges, or whatever. So people just, yes, people hate all this. So it's a fair, accurate description. It's a complete breakdown of the money that people are paying. It's so the idea is like you need to, I would say, you need to dumb it down, particularly in this consumer agreements. Dumb everything down for your consumer customers. Say terms method of payment, all this step-by-step delivery, that's rights, that's everything and anything you can imagine that you can provide with respect to your transaction, okay, in the consumer agreements. Uh, so they specifically say that yes, it needs to be fair to your customers. There is a requirement, this express opportunity to accept or decline the transaction or to correct errors. Again, a good example is our online banking. We all know that, particularly when individual banking, not business banking. Now, that's a copy of the agreement needs to be delivered, and it's an easy thing. It's the best idea. The best practice is it's either email with a hyperlink, or mail, or PDF document. So that's there are different ways. Or say the agreements can be canceled when there is no certain prescribed information provided, where, for example, there was no express opportunity to accept or decline, or when sometimes we as vendors forget to send a copy of the agreement within 30 days. I cannot imagine this happening, but apparently sometimes it happens. Okay, so that's about consumer protection. Now, more fun stuff. First of all, say we run a website, say we're selling what we're selling today. Okay, for example, we are in the home inspection business, so we just got our license as a home inspectors, and we hired our neighbor who is a IT student at Durham College, and our neighbor was nice enough to us to help us with our website. Now we need to populate our website with interesting information for our customers. And we need to talk about terms of use of our website and terms of sale. So that's our sale agreement. And they can be incorporated on our website in two different forms. It's a click wrap or browser wrap. So can someone tell me who knows the difference? Click wrap, browser wrap. Can someone help me? Any ideas? Okay, click wrap is a type of electronic agreement that you will see sometimes on a website when you're trying to proceed with a transaction or wants to read a content on the website, and then a window pops up saying, okay, please agree to our conditions or close our website. So you cannot proceed until and unless you click, okay, I agree, I understand, I read, all good, guys. I want to proceed. So it's called click wrap, and that's the best protection for you as online businesses. And browse wrap is it's a little bit, I would say, more on the lazy side of incorporating these agreements. That's browse wrap. That's what you typically see on a website sitting somewhere at the bottom of the window, just saying that legal stuff or our private policy or something. And browse wrap is, I would say, provides, in my view, provides less protection to us as online vendors, because the court, when say enforcing this browser app or click browser app agreements, they will need to see that we actually to somehow actively brought to the attention of our to the visitors to our website, that we brought to the attention the existence of this agreement. Say, okay, by reading content on our website, you agree to our privacy policy, for example, and that privacy policy is found somewhere at the bottom of the website in that fine legal print. So my preference, and when people ask in my advice, I always recommend incorporating agreements on the website in this click wrap form, so that we and your IT professionals will help you with this. It's all doable, so that say when people are reading contents on your website, first of all, the PUMs will see that um, a window opened saying, okay, please read and agree to our terms and conditions before you can proceed. Then people actually need to scroll down. Then they need to click on that I read, understood, and I agree before proceeding. And you will have a electronic record of actually them doing this active act of acceptance. Okay, so that's something that needs to be remembered. Now, specifically, terms of use and why we're doing it. Because we don't want people to steal our intellectual property when we're creating some content. We also don't want people messing around with our, say, website, or particularly, say, we want, okay, long story short, we want people behave on our website, particularly, for example, if we have or when we have some sort of a forum or chat room on our website, there should be specific rules of conduct. Okay, so terms of use of the website, typically people address well drafted agreement will address, say, general terms, conditions, products or services or information that we provide. Then obviously it's a legal stuff. Lawyers love disclaimers, all sorts of disclaimers, exclusions of liability. So we do not guarantee anything, we do not warrant anything, and we just, you on your own. Okay, just use our website at your own peril. So that's basically what we need to say. So we exclude or limit our liability. So that's a you on your own here. Okay, intellectual property, that's it's easy. We want the world to know that we are the owners of any sort of intellectual property that can be found on our website. Then acceptable use, yes, we want people to behave on our website. That's how they can use information. Typically, that's for their own use, for their own educational purposes. Okay, you want to read an article here, okay, read it, please, but don't steal it. And if you are citing it, please provide the source of it. Also, we are talking about how we collect information, how we use information, where our privacy policy can be found, and so on. And also, as I mentioned, users conduct on site, what happens when, for example, someone misbehaves in our chat room. So that's we will kick them out. And users communications, how we communicate, so what we expect from our customers and what customers can expect from us. And also that's a links to and from website, how we use these hyperlinks, and how we communicate with third parties. And also regarding the procedure, so that's substance is what we say, and procedures how we say, and we just discussed this click wrap or browser wrap things. um, Questions on this, or we're moving on.
I don't see any questions.
Yes. So the other type of, that's a like second big agreement, is that's a terms of sale. So that's our sale of services or sale of goods. Again, that's and typically, say, regarding this terms of use of website, that would be a click wrap agreement. So people are reading something, just browsing our website, fine. Now they decided to buy our product, and that's when we need to use this terms of use. For example, we, as I said, we're doing home inspection business, and someone wants to book an appointment with us, say for tomorrow, and they want our services. So they have gone through the form. For example, they provided the information, they booked particular time, they are going to pay us either e-transfer or somehow else. And obviously, at that point, we want them to sign our agreement. And how typically that works, and that's about the procedure first. How it works is, you've seen, I believe you've seen it many times, and you did those e-agreements yourself, I believe, many times. So that's they either send electronic form, or you go through the form online, and then you click at the bottom, yes, I agree, so sign electronically, and that's I read, understood, I agree, sign, and then click agree. And at that point, an electronic copy would be generated, and that would say the customer, okay, that's a copy of the signed agreement is been emailed to your email address. Or and then you find it in your email, either a PDF copy or it's a hyperlink. Or my suggestion would be do both, do PDF copy and do hyperlink. So it's better to have both than just in case. Okay. And again, terms of user agreements, general provisions, that's who we are, what we are, what we do, and so on. Products or services, again, that's a description of what actually we're selling. Then if there is any external information or documentation, okay, it can be incorporated as a hyperlink. For example, again, I'm using the same example. We're doing home inspection business, and for example, there is a code of conduct or some external documents from the Association of Home Inspectors. Then we can incorporate it as a hyperlink and say, okay, we do our business in a strict compliance with the code of conduct that is provided by this hyperlink, so that people can click, open, and read it if they're interested. Okay, so how this logistics, how we're selling, you're paying first, then we're delivering it, and so on, so on. So obviously pricing, obviously same things, lawyers favorite things, limitation of liability, representations, warranties, and so on, so on. Again, privacy, payment, delivery, return, and so on. Risk of loss, who is bearing the risk of loss at what point, and miscellaneous, it's so-called the boilerplate provisions. So that's what you need to have in your typical sales agreement, whether it's electronic agreement or paper agreement, no difference. Okay. Now that's now we are getting into these regulatory things. It's protection of privacy, and specifically in the electronic age of commerce, we have all these challenges with say hacked information, hacked websites, all sorts of this Trojan, this malware, electronic viruses, and so on, so on, so on. We're collecting someone's information. We need to make sure that it's protected, because the same way as we want to know that our information is protected when we're providing to online vendors. So, and that's, as I said, it's a legislative regime. So there is a federal PIPEDA Act. It's a Personal Information Protection Electronic Documents. It's called PIPEDA. And then there is a sequel to that. It's called Digital Privacy Act, which it's an addition. It's like addendum to PIPEDA. And so that's there is a regime of getting consent for collection and use of information. So that's we need to follow certain steps. And also it's imposing, particularly this Digital Privacy Act, it's imposing like really like it's draconian fines, horrible, horrible, horrible fines on businesses for violation of certain legislative requirements on the protection private information, and also for say taking no action in a situation of informational leaks. Again, humans are humans, bad things happen, but we need to make sure that we act properly if that happens. Okay. And specifically, we all know that typically on the website you will see on almost on every website you will see, or at least websites of the vendors that use the customers' information in their business or in the operation of the website. So it's not, again, it's not a rocket science, but there are certain requirements what we need to have on that privacy policy statement. So that's that we're accountable, who is responsible for, like say, at our end for this privacy compliance. We need to explain people the purpose why we're collecting their personal information, and we need to make sure that they provide us consent, so we do it on consent. Then we need to explain basically that so that's the idea of limiting collection, limiting use, limiting disclosure, and limiting retention of the information. So the idea is we are telling people, and actually that's what we need to do. We collect as little as possible. We use as little as possible. We disclose as little as possible, and we retain as little as possible, ideally none. Okay, and we destroy once we don't need it. Accuracy of information, safeguards. So that's if anything happens, please let us know, and so on. And openness. That's we cooperate. We make sure that we comply with the legislation and so on. So then typically, again, procedure. I always recommend all these agreements and all these statements to have in click wrap form, so that before people actually providing you information, any sort of information, say their name, when they're registering, when they're signing up on your website. So that's a way explaining them what we're doing, and we require them to actually agree to our rules before they can proceed. Okay. Now, castle compliance. So that's this anti-spam legislation. So that's a Canadian anti-spam legislation. There are several um, legislative documents that's forming together this so-called castle legislation, and it's that's the regime that protects us from being flooded by unsolicited electronic, say, like, commercial marketing emails, electronic advertising. So that's first of all, thanks to this regime, that we can somehow plow through our email inboxes without being flooded. But also, we need to make sure that we are compliant with this regime. Okay, because this castle legislation, it prohibits selling unsolicited communications, and also it imposes again crazy fines, very, very, very painful fines. So we want to stay compliant. Okay. And specifically with these communications, we need to make sure that to stay compliant, we need either to have implicit consent. So that's a consent from consent implied from conduct. So that's our existing customers, or it's our friends, or it's someone who provided publicly their information, or it can be explicit consent, which is always better than implicit, so that there is no issue, there is no misunderstanding. So before sending something, ask permission. Okay, and always we need to make sure that we are given an option to opt out. Say, you know, all this. Like we have seen it many times, like gazillions of times. So we have this getting someone's electronic newsletter in our email box, and at the bottom there will be this unsubscribe option. So you know what we're talking about right now. Okay, and how to stay compliant. First, decide whether castle applies to you, and I'm prepared to bet. I'm prepared to bet for any sum of money, up to 25 cents, that more likely than not that castle applies to you and to me in our commercial communications. So get express consent from your existing clients, customers, or uh, like, yes, even if you think you have implicit consent, just get express one. Okay, and also that's a good idea, it's a good business practice to update your all your forms and all your registration or sign up forms, to make sure that you're asking your customers or prospective customers permission to send them your marketing information. Okay, and keep your communication themselves compliant, and we will be talking in a second about this. Okay, so number one, decide whether this castle applies to you. And as I said, most likely it will apply, because when we're talking about commercial communications, that's how they say it. It's information communicated with a purpose to encourage participation, to encourage someone to participate in commercial activity. And yes, that's basically what we're doing. And if we're just including our logo in that email or our link to our website, it's fine. It's not spam. And electronic, that's meaning transmitted through email, instant messages, WhatsApp, Facebook, or telephone, or some other things. And as I said, it's a direct message. Say it's a Facebook Messenger, it's a WhatsApp, it's a Viber, it's say Telegram. So all is covered. What is excluded? It's excluded this voice calls, fax message, and that's for a reason, because it's covered by another regime. So that's a broadcasting legislation covers these types of communications, and basically to the same end of prohibition of unsolicited communications. Okay. Second, implied consent. Make sure that say implied consent, that's already your customers, or it's your non-commercial relationship, or someone posted their contact information publicly, or it's specifically provided. Okay, so you can imply you have consent. Still, it's better to confirm this express consent, subscribe, unsubscribe. So that's to make sure that you do your CYA. Okay. Now, communication themselves. When you're sending someone's a newsletter or some email with your promotionals, sales materials, and so on. Obviously, it's identify yourself as a vendor, provide full contact information, and specifically provide this mechanism to unsubscribe. Okay. Um, okay. Now, here's my practical advice. Say when you are getting your express consent, particularly at the point of it's better to do it at the point of when the people are registering on your website. Okay. Say someone is registering for your services or provide information. It's a good idea at that point to ask, like, would you mind receiving some newsletters or market information from us every once in a while, and yes or no. And the chance is that people would be more inclined to say, no, I'm fine, thanks. That's because I'd like to give another piece of advice. Rather than asking, would you like to receive market information from us? No, thanks. It's better to ask, would you like to receive our market updates or some market information or our newsletter, say once a year or on a quarterly basis or once a month or maybe weekly updates? Then there is a good chance that someone say, well, every week is it's too much. Every month, I'm not sure I need it. Well, maybe once a year or maybe once a quarter, I would not mind getting the marketing information anytime. I can unsubscribe if you don't like it. So that's a tip for you. Okay. Now, okay, we're almost there. To summarize, when you're running business online, first of all, you will want terms of use of your website, and I would recommend the click wrap form. Then you want to sell your goods or services on a particular terms known to your customers. And that's why you will want this, it can be called different ways, just agreement of sale, terms of sale, or I mean, you can call it whatever you like. Okay, and that's you need a mechanism to make this document accessible and retainable by your customers. Okay, and your say your lawyer and your IT professional will help you with these documents. And in addition, you will need as a CYA documents, you will need this privacy policy and cookie use policy on your website, because most likely than not that you will be collecting personal information from your customers in order to transact with them. Okay, and again, I would highly recommend making it a click wrap form. And finally, when you're sending your marketing information, like obviously we need to communicate with people. We need the world to know about our services or goods that we're selling. So we do need to communicate with our prospective clients. So we do need to send our cold call emails. So we just need to stay compliant with this anti-spam legislation. Okay. What else to say? Yes. Ah, just a couple words. I realized that I just wanted to clarify. I believe that everyone knows what cookies are, but just in case, it's little pieces, it's a little files of information about us, about our IP address, about the routes that we follow on internet. So they need, there are some cookies that are used by websites and web participants by necessity. And some other cookies are used to collect our information to be used for commercial or marketing purposes. So that's there are some, like as I said, necessary service-oriented cookies. We need them, and one cannot like sell them. It's needed. And but also that's it's to collect some statistical data. It's collecting some data about what we do on the website. So there is an example. We all know that once we went on Google and say typed a red Dodge pickup truck, then somehow surprisingly when in our Facebook or whatever we're doing on the website, we'll have these banners popping up. Poops, red Dodge pickup truck. Pooms, oh, red Dodge pickup, or just pickup truck, Dodge, red something. So that's that's thanks cookies. So we can regulate how cookies are used and how this information is used. And again, it's typically it's a part of privacy policy, but we do need to advise our customers or prospective customers how this information is collected and used, and to give them an option to minimize the use of cookies and collection of cookies to the very necessary minimum if needed. Okay, so that's something to be mindful about. Well, that's it. So questions. I like answering questions. Please ask me.